When construction concludes, clients take possession of a physical structure, concrete, glass, and steel. But the architect walks away owning an invisible, intangible asset. This is spatial copyright. By law, the architect or interior designer retains ownership of the design itself, which exists as a legal entity separate from the physical property. Managing this asset carries massive stakes. It grants creators legal control over a building's future and provides eligibility for a lucrative patent team. This creates a strange paradox. Civil courts aggressively protect these designs as works of art to shield them from client interference, while the National Tax Authority scrutinizes those same designs to deny financial benefits. Success in this field involves navigating this dual legal reality. Physical bricks provide less financial utility if the creator lacks control over the invisible blueprint. For an architectural or interior work to earn civil protection, it must reflect the author's free and creative choices. The design cannot be dictated entirely by technical constraints or structural engineering. This is the Brompton folding bicycle. In a landmark case, the courts determined that even highly functional mechanical objects possess copyright, as long as the designer had a margin of creative freedom in shaping the form. This protection scales up to monumental architecture, like La Grande Arc de la Défense. Blueprints, scale models, and the massive structures themselves are all classified as legally protected works of the mind. This classification leads to a frequent legal collision. A client buys a building and decides to add an unapproved extension or paint a mural over the facade without the architect's consent. When this happens, the creator can invoke their moral right to integrity. This allows the architect to block alterations that compromise the design or damage their professional reputation. Paying the final construction invoice does not transfer the copyright. The creator's civil shield remains intact unless those rights are explicitly signed away in a written contract. This legal status enables a massive financial benefit. Under Belgian law, copyright royalties are taxed as movable income at a flat rate of 15%, often with a 50% deduction for expenses. However, the Service des Décisions Anticipées, the Belgian Ruling Commission, subjects spatial creators to intense scrutiny to ensure this favorable system isn't abused. To see if a project qualifies for the tax benefit, the authority uses these 6 distinct axes of fiscal control. The biggest stumbling block is the 4th axis. The authority requires proof the work is actively exploited, meaning communicated to a public audience. This creates a trap for residential designers. A single-family home for a private client is a restricted circle. It fails the public communication test, which disqualifies the architect from the copyright tax benefit. The dual reality of spatial design is clear. A private home is a protected work of art when dealing with a client, but it remains invisible to the tax authority without a public audience. Managing these rights requires an operational shift. Spatial creators cannot rely on verbal agreements, and simply issuing an invoice does nothing to secure these protections. A written contract is a necessity. It must explicitly separate the transfer of physical property rights from the licensing of intellectual property. There are no retroactive loopholes. Simply uploading a private home's blueprints to a firm's portfolio after construction does not satisfy the strict requirement for public communication. Accessing the tax benefit requires documented proof that the design was intended for a public audience from the start, such as a retail space, a museum, or a public facility. True ownership of a space requires a dual strategy, wielding the civil shield to protect the integrity of the art, while navigating the fiscal labyrinth to protect the income it generates. The information presented here provides a general overview of the legal and tax landscape for spatial creators in Belgium and does not constitute formal legal or financial advice. Always consult a qualified professional.